Welcome, everyone, to the Mona Charen Show. So glad you could join us. I am delighted today to welcome back Georgetown law professor Stephen Vladeck, who writes on the most cutting-edge legal issues in his Substack, One First, which, if you're not getting it, I highly recommend. And so, Steve, good to see you again. Thank you for being here.
You too, Mona. Great to be back.
So the first thing I'd like to tackle is the Attorney General's opening of an investigation or disciplinary hearing or something regarding James Boasberg, Judge James Boasberg. This really smacks of authoritarian sort of tactics here. Why don't you... For a little bit of background for people who may not remember who Judge Boasberg is, he is a district court judge in D.C. He is the judge who heard the Abrego Garcia case and who ordered the planes to turn around and who believes and has said that, the administration lied to him. But okay, so if you wouldn't mind, just lay out what it is the Attorney General has done and why it worries you so much.
Sure. Gosh, where to begin? So the story starts a couple of weeks ago with a piece that was posted on the very pro-Trump outlet, The Federalist, where The Federalist reported on a leaked memorandum from a March 11th meeting, Mona, of something called the Judicial Conference. A lot of folks don't know what the Judicial Conference is. To make a very long story short, it is the basically policy-making body of the entire federal courts. It's a group of 26 judges led by Chief Justice John Roberts. The chief judges of each of the federal courts of appeals is on the Judicial Conference. And then within each of the circuits, there's one district judge who basically represents all of the district judges. And the Judicial Conference exists. It was created 100 years ago for exactly the purpose of providing a means by which judges could pool resources, could identify common problems, and could, when necessary, recommend reforms or other sort of remedies for common problems the judiciary is facing. So the Judicial Conference meets a couple times a year. It looks at docket issues, Mona. It looks at judicial security, which has been a huge issue of late. Sure. Mm-hmm. Budgets, I mean, you name it. It's stuff that tends to be relatively anodyne. Mm-hmm. So this time around, the Federalist report was that at the March meeting of the Judicial Conference, Chief Judge Boasberg, who is the district court representative for the D.C. Circuit, was asked basically by Chief Justice Roberts, hey, what's going on in your court? And Boasberg responded that a handful of his colleagues had concerns that the Trump administration might not comply with rulings against it, both in then pending cases and going forward. And Mona, that should have been the end of it. Apparently, the entire sort of proceedings of the entire conference were memorialized by one of its attendees in a memorandum that was then circulated to their colleagues. And then that memo was leaked to the Federalist for some reason, sometime in the last month. Right. And once the Federalist published this story, that apparently got the wheels going inside the Justice Department, because the department filed last Monday a formal judicial misconduct complaint against Chief Judge Boasberg, Mona, that is based almost entirely on the memorandum, which, oh, by the way, was not attached to the complaint. So, what we have
didn't it say, just correct me if I'm wrong, but didn't the Attorney General say that Boasberg had publicly criticized, whereas this was a private conversation right?
So there's a lot that is wrong with the memo. The memo takes a series of factual liberties, Mona, not just in the abstract, but even off of the Federalist report, which I don't think is necessarily a fair presentation.
Accurate, yeah.
Right?
Yeah.
So, the memo the complaint repeatedly asserts that Boasberg's comments were public. They clearly were not. The memo, I wouldn't necessarily expect the Federalists to delve into the nuance of what the Judicial Conference does, but the memo makes it seem like the conversation was totally out of bounds for the Judicial Conference, when, of course, like, what's going on in your district courts is actually kind of the whole purpose of the Judicial Conference. Right. So, the memo is really sort of not very, how do I say, accurate about the facts. It is even worse when it comes to the law. Because the law here is what's called the Code of Conduct for United States judges, and it has a series of canons that the complaint claims Boasberg violated. But one of those canons is about public comments. These weren't they. One of the canons is about commenting on a specific case, but the only case that the complaint specifically refers to is the Alien Enemies Act case known as JGG, which, Mona, wasn't filed at the time of Boasberg's comments. President Trump hadn't even signed the proclamation, invoking the Alien Enemy Act at the time of these comments. And so it is, I don't mean to sort of make light of a misconduct complaint. Like, there's a reason why we have this process under something called the Judicial Conduct and Disability Act of 1980. But for the Department of Justice to file such a factually inaccurate and legally frivolous complaint against a judge in this context, I think is really, really alarming.
And because it's so clearly an attempt to retaliate against the judge for taking a position that they don't like.
Well, more than that, I mean, I think the complaint doesn't just attack Chief Judge Boasberg. It asks for, the cases involving President Trump that are currently before him to be reassigned. While Judge Boasberg is, Mona, still in the middle of adjudicating whether various government officials should be held in contempt for their behavior in the JGG case with regard to the flights of Venezuelan migrants to El Salvador. So I guess I wrote about this for my newsletter last week. I am less worried about Chief Judge Boasberg. He tends to be, in my experience, someone who does not lightly suffer fools. Mm-hmm. But I do think that the broader visual of this for other federal district court judges who now might be worried about being the next folks against whom such a misconduct complaint is lodged, and Mona, for Trump's base, where I think you can put this in a list of efforts on the part of both the executive branch and its supporters to foster this perception of district judges run amok. Where, just the existence of this complaint can be pointed to as evidence of misbehavior, when all it takes is, reading the complaint carefully and comparing it even to the Federalist story, let alone to what actually is how the Judicial Conference works, to see how there's just no there. So I guess I'm less worried about Boasberg in this context than I am about the broader message it sends about this administration's relationship with the lower federal courts.
So maybe like me, you really like to cook, but you don't always have time. Life gets really busy. That's why it is so great to have something to fall back on, like a prepared food where it's going to be high quality. And that's where Factor comes in. Factor has more than 65 weekly meals made for exactly what you might need. You can specify gluten-free, or, you want to be high protein, or, they are so specific in what they will let you pick. And the food is really, really good. It's fresh, and delicious. So you can support your wellness goals, even GLP-1 friendly meals. They have those. They have Mediterranean diet options, which is my personal choice. And also you can now savor all kinds of global cuisines. They have Asian inspired meals from China, Thailand. Great stuff. Both for nutrition and flavor, Factor stands above other food services. So eat smart at factormeals.com/MonaCharen50off and use code MonaCharen50off to get 50% off your first box. Plus, free breakfast for 1 year. That's code Mona Charen 50 off at factormeals.com for 50% off your first box plus free breakfast for 1 year. Get delicious, ready-to-eat meals delivered with Factor. Offer only valid for new Factor customers with code and qualifying auto-renewing subscription purchase. All fair points, but you know what I'm worried about? I'm worried about the fact that the world is upside down, that somebody like Boasberg, who is a great judge, who, calls them as he sees them and who is ethical and is simply doing his job the way we expect a federal judge to do his job, is in theory, facing this kind of professional danger, even if, as you say, he's a tough guy and he'll be okay, but still it's a bad message. And then the kinds of things that you see where there are no consequences for people in the Justice Department who really are guilty of misconduct, who really are lying to federal judges, for example. There's a story that I just pulled from the paper from a couple days ago. This was in the New York Times, that a legal watchdog group called the Legal Accountability Center has filed a complaint with the bar associations in a few different cities regarding the behavior of some of these Justice Department lawyers who have demonstrably lied to federal courts. And I raise this because it just feels like there are no consequences for the people who really are misbehaving. And, where are the guardrails? Is this one of them? The bar associations, they've been pretty weak sauce in the past.
So I guess, I certainly agree that there aren't enough consequences. I think there are two different sets of consequences that we are seeing in action, although the proof may actually just be that those consequences are insufficient. So the first is, the bar difficulties, the bar proceedings, I think is a meaningful lever. It's just an awfully slow one. And so just to give an example, one of the headlines from last week was, I've lost track if it was Thursday or Friday, but last week, the DC bar formally recommended the disbarment of Jeffrey Clark, former Justice Department lawyer, for his role in the January 6th machinations. Right. Well, that's great, but here it is, August of 2025. And, even if that's the ultimate penalty for Clark, and I believe that it should be, that was slow, right?
Yeah.
It wouldn't surprise me, for instance, if we start to see similar charges against Attorney General Bondi, related to both the filing of this complaint, which was signed only by her chief of staff, Chad Mizell, and maybe other behavior. So, I wouldn't sleep on the disbarment route. I think it's slow and cumbersome. I'm not sure that that's a bug. I think that there's virtue, at least in some cases, to the deliberateness of it. But one of the other piece of it, which I think we're not talking about enough, is how the just complete hatchet that has been taken to the Department of Justice's credibility is starting to show up in other cases. There was a random, criminal case last week, not a political case, not a headline generating case, where a judge just dropped a footnote about how it's increasingly difficult to take the Justice Department's representations at face value, right, in a context in which there was no reason to suspect partisan political interference, right? And so I guess, I don't know that we should be satisfied by the erosion of the presumption of regularity, which actually really worries me in the long term, or by bar discipline. But I think, there are consequences that are starting to manifest. Mona, I think it's part of why they've singled out Chief Judge Boasberg, because Boasberg has been perhaps the most visible judge in the country so far in efforts to hold these lawyers accountable for their representations, and why perhaps someone in the Justice Department thought he'd be a good target. Of course, the problem is that, the emperor in this case really is wearing no clothes. And that's what we're seeing when a lot of these charges and allegations get really subjected to meaningful scrutiny.
I guess there's really not too much to say about the fact that another one of the officials in the Department of Justice who is guilty of a number of aspects of professional misconduct, namely Emile Beauvais. His consequence was that he got kicked up to be an appeals court judge and is probably being prepared to be Trump's next nominee to the Supreme Court.
So I'll just say that being a judge is no obstacle to facing disciplinary measures within your own state bar.
Okay.
It wouldn't necessarily undermine Beauvais' judgeship were he to be disbarred, but at least it would maybe send the right message about what kind of lawyer he is.
God, would it? That would
also,
be great.
I think, but Mona, your point is, I think, right in multiple dimensions, because the confirmation of now Judge Beauvais, I think, is really a powerful sign of how one of the other accountability mechanisms, which was, the Senate, has just completely fallen apart. And not that long ago, Mona, you and I are old enough to remember the U.S. attorney scandal from the Bush administration in 2006 and 2007. What's happening right now makes that look like tiddlywinks.
Absolutely.
Right.
Yep.
And the reason why that scandal became a scandal is because there were enough Republicans in both chambers of Congress who would not abide by the sort of shameless politicization of U.S. attorneys' offices. Clearly, that's not where we are today. And so I think these are just yet further lessons in how the absence of any institutional check from Congress is, removing various guardrails to behavior that I suspect you and I would have thought was, inconceivable as something that would come from the government in the past. Just one last point on the misconduct complaint. Even publicizing it is technically unlawful. Right? Judicial misconduct
note there, and to the rules, so they're
right.
not supposed to make it public.
Right. And so, it's just it's become commonplace for folks to sort of wave their hand at the degree of lawlessness that's going on. But like in everything we're seeing, we are seeing lawless behavior by the executive branch that is being enabled to a large degree by the complete absence of Congress. And I think.
Right. So let's talk some more about some of those, because, again, it feels like the world is upside down. So let's talk about what the administration is doing vis-a-vis the universities. You're smiling. You look exasperated already. Look, in order to make war on the universities, the administration says, well, we find, sort of out of thin air, we find that you are guilty of tolerating anti-Semitism. And therefore, in exchange, we're going to cut off your funding. And unless you do the following things, and of course, Columbia, my alma mater, just completely capitulated and said, let us, we're going to agree to this whole series of demands. So on so many levels, Stephen, I want you to sort of spell this out for our listeners and viewers. So on so many levels, for one thing, the administration, where is the process here? Is there an investigation as to whether there was anti-Semitism? Is there a finding? Is there an administrative procedure of any kind? No. Is there a lawsuit filed on the part of Columbia saying you can't just abrogate contracts as the federal government, right? We're going to sue you for breach of contract. Nothing like that. And the notion that the administration can, completely, even if you believe in I'm throwing a lot of things out, and I'm sorry, I'm angry. Even if you believe in the unitary executive theory, it doesn't mean, does it, that the administration, that the president, when he does something, can do it in an arbitrary and capricious manner, right? So anyway, respond to any and all of that, please.
I'm going to start in a bit of a strange place, but I think you'll see where I'm going.
Okay.
I think one of the most revealing episodes of the last few weeks was when President Trump fired the chief statistician in the Bureau of Labor Statistics at the Department of Labor after a bad jobs report, right? And the reason why I find that so revealing, and the reason why I think it ties deeply to the university piece, is because here's someone who is just a mathematician. And I don't mean just as like I was a math major. I do not mean that as a derogatory word.
Sure.
Right?
Yeah.
They have no political agenda, right? Their job is to be as accurate as possible in compiling a very important set of economic measures Mona, on which a heck of a lot of people rely. I mean, this is
Yes.
the same office that compiles the Consumer Price Index. Um, that firing is made legally possible by the unitary executive theory and by the idea that no matter what your job is in the executive branch, the president can fire you at any time for any reason. In a world in which we had a more coherent theory that there are some jobs that should just be independent of that kind of pressure, that couldn't happen. That move is made politically possible by the fecklessness of congressional Republicans who would otherwise threaten to shut down every single nominee for the Department of Labor, if not across the entire executive branch, right? Unless they got to exact a pound of flesh for whoever the next person is, right? And these are the kinds of moves that are only made possible because, as you say, the world is upside down. And the same is true of the universities. I am able to be here with you on this podcast telling you what I think because I am not teaching at a university that has been subject to this kind of intimidation, because I am no longer teaching at a public university in a red state where me being visible would potentially hurt my colleagues and my students. Right? Academic freedom is a real thing. And the more that you are undermining academic freedom at the government level, as opposed to privately, the more you are doing to universities what you're doing to the Bureau of Labor Statistics, the more you're putting a thumb on the scale of sort of what truth is and what science is and what math is in ways where all of a sudden things that we had just taken for granted as foundational building blocks of our culture start to become less than trustworthy. Where the government puts out a jobs forecast that people don't believe, right? Where the government puts out a weather report that people don't believe, where the government says this drug is safe and people don't believe it.
Or where the government says there is no spread of measles in Texas.
And people don't believe it. Right. And so, and this is why trust is such an important and ephemeral quality in government. And it's why trust is important for academics, and it's why trust is important in universities. And so, what just drives me absolutely bananas about where we are is just how short-term and myopic and clumsy it all is. Because even if you are scoring short-term victories in the culture wars, what's left at the end of this, right? I mean, presumably Trump wants an economy that has reliable metrics on which investors can, base their behavior, right? Presumably Trump wants the ability to say, the United States is actually able to generate, among other things, right, important developments in science and other, fields of study. Right. But
I don't think he cares.
Well, therein lies the rub, right? Which is that for the first time, I think, in our history, right, we have a president who is fixated entirely on what can be credited to him in the short term and nothing past that horizon. And so it's like Tom and Daisy in The Great Gatsby. Like there's just, what you destroy in the process becomes, if not, not just a relevant moment, but perhaps even part of the fun.
The old adage, you are what you eat, rings very true to all of us in the modern day. And I'm always looking for an on-the-go protein snack that satisfies me. But now I found one that helps me to live intentionally, too. Mosh bars. Mosh, which you may have heard about on Shark Tank, was founded by Maria Shriver and her son, Patrick Schwarzenegger, with a simple mission to create a conversation about brain health through food, education, and research. Maria's father suffered from Alzheimer's, and since then, she and Patrick have dedicated themselves to finding ways to help other families dealing with this debilitating disease. Mosh joined forces with the world's top scientists and functional nutritionists to go beyond your average protein bar. With 8 delicious flavors, including a plant-based one in peanut butter and chocolate, each Mosh bar is made with ingredients that support brain health, like ashwagandha, lion's mane, collagen, and omega-3s. And now, Mosh bars come with a new look and a new formulation featuring a game-changing, brain-boosting ingredient you won't find in any other bar. Mosh is now the first and only food brand boosted with cognizin, a premium nootropic that supplies the brain with a patented form of acetylcholine. But here's the best part to make you feel good. Mosh donates a portion of all proceeds from your order to fund gender-based brain health research through the Women's Alzheimer's Movement. Why gender-based? Because 2/3 of all Alzheimer's patients are women. Mosh is working closely to close the gap between women and men's health research. These bars are delicious, and they give so many choices that you'll be sure to find something that will just be perfect for you. I love the blueberry almond bars, and I also love the fact that none of them has more than 3 grams of sugar. If you want to find ways to give back to others and fuel your body and your brain, Mosh bars are the perfect choice for you. Head to moshlife.com/Mona to save 20% off plus free shipping on the bestsellers trial pack. That's 20% off plus free shipping on the bestsellers trial pack at moshlife, that's MOSHLIFE.com/Mona. Thank you, Mosh, for sponsoring this episode.
Let's talk a little bit more about the president's authority. Okay. So on a number of fronts, we have seen what I regard as utterly risible legal arguments being advanced by this administration. And yet there's precious little pushback. Now, partly that's because the judicial process is slow. And some of these things may yet come back to bite him. But let's talk about some of them. So, for example, on the matter of tariffs, the president is relying upon authority he claims under IEEPA, which is a great word to say. It's the International Emergency Economic Powers Act of 1977, which was actually a post-Watergate reform that was meant to constrain the president's authority.
Yep.
And under IEEPA, there are a series of things that lays out, and it's not a poorly written piece of legislation. It's pretty easy to understand. And it specifies that in certain emergency situations, the president has certain authority. It's never been used to impose tariffs. And the idea that, it requires the president to declare an emergency before using powers under this act. And the declared emergency that this president has used is that we have been running trade deficits with various countries for decades. Now, how something that's been going on for decades can be an emergency is a great question. And I just wonder, people, won't the courts, I keep waiting, won't the courts say, that's ridiculous?
So one court, or I guess 2 courts already have.
Okay.
Right. A court no one's ever heard of called the U.S. Court of International Trade in New York has said so, as has a federal district court in Washington, D.C. Mona, just last week, the full, or as we lawyers like to say, en banc federal circuit, the federal appeals court that hears appeals from the Court of International Trade, heard oral argument. By the media accounts, it did not go well for the Trump administration. So, it is possible that the tariffs are indeed going to end up on the legal chopping block. I will just say I think that case goes to the U.S. Supreme Court one way or the other. But part of what's going on, and you and I have talked about this before, but I think it's worth coming back to, that part of what's happening is a large gap between the law on the books and the law on the ground, partly because of these various interventions by the Supreme Court, by other appellate courts, where you'll have district courts, or in this one case, the Court of International Trade, blocking what Trump is doing. And you'll have, in a small number of cases, appeals courts, and in a slightly larger number of cases, the Supreme Court, putting back into place whatever Trump is doing while the legal process works its way forward. And what's striking about, so there have now been, by my count, 16 Supreme Court decisions alone just since, April, that have done this for Trump initiatives, where the justices, without fully endorsing the government's behavior on the merits, Mona, in some cases without endorsing it at all, right, have nevertheless allowed the government to continue doing what it's doing. And Mona, I think part of the complication here is that, you could tell a story in normal times about how that's institutionally responsible behavior by the Supreme Court, right? About how it's, giving the benefit of the doubt to the democratically elected representatives at the federal level, that the court is preserving for itself the power to ultimately decide these things are unlawful after they've fully percolated through the lower courts, right? And that story, I think, would be persuasive at almost any other moment in American history. The problem is twofold here. There is so much of it happening, and the harms are in many cases so irrevocable that I think there's a real concern that the court is being naive, right, about what it's enabling by letting these actions go forward, even when they might ultimately be adjudged unlawful.
Steve, that's a strange word to apply to the 9 justices, naive. I mean, these are men and women of the world. I can't imagine that they don't know exactly what they're doing. And let me tell a little story.
Please.
So, a couple months ago, however long ago it was, I was excited to be told that we were going to have hearing, an oral argument for the Supreme Court on the matter of birthright citizenship. And I'm all excited. Then I look it up. It's like, I tune in. Let's hear the argument about birthright citizenship. And what do I find? They're not arguing about birthright citizenship. They're not arguing that Trump has just done something so flagrantly unconstitutional, where the 14th Amendment is quite clear and all the legal scholars agree that the 14th Amendment grants birthright citizenship, et cetera, et cetera. No, they decided, the justices in their wisdom decided this was the moment to have a big debate about nationwide injunctions.
Yep.
And they could have done that on many other occasions, right? There was a big debate about that just most recently during Biden's term over the student loan forgiveness or, other things where there were nationwide injunctions. And they didn't do it then, but now they're doing it. And I cannot I want to believe the best of these people. I do. But honestly, I don't think that was a good faith decision. Why choose now on this most important matter where it really would have been clarifying and wholesome and healthy for the Supreme Court to say, absolutely, this is what the Constitution says. Sorry, what is your interpretation of that? So
my interpretation, I think, is closer to yours than you might think from my prior comment. But let me take a stab at a counter argument.
Okay.
The counter argument goes like this. Historically, what protected the Supreme Court's power, right, and what made the court's mandates enforceable was diffuse, broad spectrum public support for the Supreme Court as an institution. Not that we would all agree with each of the court's decisions, but that we would all agree that in general, the court was behaving judiciously, and any elected official who defied the court or who refused to enforce the court's mandates was worthy of, repudiation. This is why, President Eisenhower sends the army into Little Rock in 1957 to enforce Brown. It's why Nixon complies with the subpoena to produce the very tape that forces his resignation from office, right? We live in a world with very different public views of the Supreme Court than there were in 1974 and 1957. And, whoever's responsible for the erosion of public support for the court, there has been significant public erosion in support for the court. And so I think you could tell a story that's not about Justice Thomas or Justice Alito or Justice Gorsuch, but that might be about Chief Justice Roberts and Justice Barrett, and maybe a little bit of Justice Kavanaugh, that they are very worried about the specter of Trump telling them to pound sand. that they see how quickly Congress has rolled over, that they see how quickly other institutions like Columbia have rolled over, and that they are worried that if they all of a sudden start standing up to Trump in case after case after case after case, right, at some point they will not be able to enforce their mandates, right, and they'll become irrelevant. And there's nothing that the justices like more than, their own power, right? Against that backdrop, a world where you have this technical, procedural, quirky, nerdy option of granting, emergency applications without having to explain yourself and pushing all of these disputes down the pike, 18 months, 2 years, 3 years, might not look that bad. I don't like that if that's what's happening. There's a reason why Neville Chamberlain is reviled by most historians for what he did at Munich. But I don't know that it's completely irrational. And so, it's when I say naive, I don't mean like they are sort of like, they just fell off the turnip truck. But maybe they are naive about sort of what is happening in the interim, like what the trade-offs are when, for example, they let the Trump administration cut the Department of Education in half. Right, when they allow for the removal of tens of thousands of migrants to third countries where those individuals might face deplorable treatment, right? That those are bells that are going to be awfully hard to unring if, in fact, at some point in the future, the court wants to rein this in. That's my concern. If, in fact, there's just, a majority to uphold all of this, then, we have bigger problems.
Yeah, we have bigger problems. Well, so I would add to your list, I have another concern, and it's this. You argue, well, they're husbanding their authority and they're biding their time because they fear that if they come into direct conflict with Trump at this stage, he might tell them to go pound sand and the public might support him in that and not them. But here's my worry about that, which is there is a momentum to these things. And the more capitulation that there is by various institutions, the more you'll get. And so it creates its own momentum and the courts are the one institution, I believe, that during the first Trump administration really held its own and conducted themselves quite well, and maintained their integrity. And to see the courts now also seeming to be cowed, may give encouragement to the authoritarians, rather than, just being cautious and waiting for their opportunity.
It's really frustrating when someone makes my own arguments against me. But yes, no, I mean, that's right. I mean, I agree with all of that. And this has been when folks who I really admire and respect, who are, maybe for lack of a better term, center right defenders of the Supreme Court, but not Trump, unpack these kinds of arguments, right? My response is exactly that, which is, just take a case like the so-called the DVD case, which is the unhelpful name of the third country removals case.
Right.
Right. So in that case, maybe the government had plausible legal arguments for why the Boston federal judge didn't have the power to block removals to third countries. But no one disputes that the government openly defied his order. And for the Supreme Court to grant emergency relief in the face of the government having openly defied the district court has to be an invitation for the government to do that again. And that's why I come back to the Boasberg story, because to me, these are all of a piece, which is, the courts, I think I would sort of cut out, right? The lower federal courts, I think, have been doing yeoman work in dealing with an unprecedented number of high profile, challenging, messy cases against the Trump administration. I don't agree with all the decisions, but I think that these district judges really are doing their level best. And you have this subset, right? This very, very carefully selected subset of cases that the Trump administration is choosing to bring to the Supreme Court, where the justices at least appear to be saying, right, we are sort of, if not indifferent to the consequences of our interventions. We are willing to tolerate the consequences of our interventions. I mean, you even had Justice Kavanaugh last week at the Eighth Circuit Judicial Conference saying to a room full of judges and lawyers, there are costs when we explain our decisions. My response is, but there are costs when you don't.
Absolutely.
And so this is my concern, is that, you say sort of whether it's momentum, inertia, desensitization, I mean, whatever it is that accrues from all of these things being allowed to continue, it seems to me that the end game is all to put the courts in a relatively weaker position vis-a-vis the executive branch if and when that confrontation comes. And, I used this line the other day. I think it rather captures the point. A lot of folks are sitting around waiting for a crossing the Rubicon moment, right? When I think a lot of what the Trump administration is doing is trying to find if there are other sneakier ways that folks won't notice to get into Rome. And that's the problem of where we are.
Yeah. Let's talk for a minute, because it's related to this. I see a connection between what they are doing with Boasberg and what they are doing with Jack Smith. And so that is also the kind of worrying, retaliatory behavior on the part of those in power that you really do fear in a lawless kind of country. So
we're not weaponizing the Department of Justice as we weaponize the Department of Justice.
Yeah, exactly. In fact, they came into office swearing that this was the absolute end of the weaponization of justice. And it is, again, the world is upside down. Yes. It was not the weaponization of justice when Jack Smith was duly appointed by the Attorney General to investigate, et cetera. But this, well, why don't you talk about that?
I mean, it's a good thing George Orwell is dead, because if he were alive, he would sue all of us for copyright infringement.
Yes.
So, what's basically going on here is it has, you're so right. It has so many parallels to the Boasberg complaint. It is an entirely manufactured controversy where the, Trump installed head of what's known as the Office of the Special Counsel, which is not to be confused with special counsels like Jack Smith.
Right.
And if folks remember, right, this was actually the first flashpoint for Trump firing somebody when he fired Hampton Dellinger, who was then the head of the Office of the Special Counsel. Yeah. So one of the things the Office of the Special Counsel does is it enforces a statute known as the Hatch Act. The Hatch Act is, anyone who has spent any time in Washington has that exact sort of sad chuckle reaction that Nona has to any invocation of the Hatch Act, because the Hatch Act is really like a statute that is defined by non-compliance with it.
Right.
The general idea of the Hatch Act,
especially by the first Trump administration.
Right. So the Hatch Act is generally about limiting partisan political activity by government employees while they are on the government dime.
Yes.
It is principally civil. It has a couple of criminal provisions for super extremely bad behavior. But coming from the people who hosted the Republican National Convention at the White House.
At the White House.
And, there's a quote. I've been trying for a couple of days to find this quote. Kellyanne Conway.
I remember that. Yes. Right? She said, what are you going to do? So she said, sue me or something.
Right.
Yeah.
Right.
Yeah.
Who basically said during the first Trump administration, the Hatch Act is like a nothing, don't threaten me with a good time. But now, Jack Smith is worthy of being, shipped off to the gulag because of a violation of a statute. By the way, I'm not even sure that the claim comes close to stating a violation of the Hatch Act, right? And so,
by the way, if this violated the Hatch Act, if him investigating, then we could never have any public corruption investigations forever, right? Yep. Of any official.
Right. I mean, it is. We're back to the problem of, is it ever possible to believe that the government might be investigating someone of the other party for legitimate reasons?
Right.
Right. And if you really think the answer is no, well, that is an awfully cynical world to walk around in. Right. So, it is, to me, Mona, it's all of a piece, because this won't go anywhere. Jack Smith is not going to jail. But, in the interim, a couple things are going to happen. The base is going to get fired up. Right. People are going to point to this as proof that the conspiracy theories were true, Jack Smith is going to have to, deal yet further with the personal, economic and emotional cost of defending himself against this nonsense. And other folks are going to think twice the next time they're put in a position where they might be a future Jack Smith. And, that's a real shame.
It is. All right. So you are one of the preeminent analysts of the Supreme Court. And so I would love to hear your understanding of their reasoning vis-a-vis these executive branch agencies, okay, and independent agencies. So, and you can maybe talk a little bit about what Humphrey's executor did and all that. But here's the thing. Trump has been going around firing the Democratic members of, agencies where Congress specified we're going to have half Democrats, half Republicans are going to be on the board of this agency. And he's been firing all the Democrats or just, firing whoever he wants. And the Supreme Court, in one case that I found mystifying, so I would love to hear your views on this, they said, well, this is all fine, because he has the authority, except when it comes to the Federal Reserve.
Right.
So, well, what?
Yes, as Justice Kagan put it, the bespoke exception for the Federal Reserve. Oh boy.
Yeah.
Okay.
Yeah.
So, the unitary executive theory, in a nutshell, right, is the idea that when Article 2, Section 1 of the Constitution invest, quote, the executive power, unquote, in the President of the United States, it means to invest every single possible iota of that power in the president specifically, meaning no one can exercise that executive power unless they are directly accountable to the president. That is the theory taken to its, sort of natural conclusion. That theory had never been supported by the Supreme Court in any context until Justice Scalia gave it voice in a dissenting opinion in 1988 in a case called Morrison versus Olson, where by a 7-1 majority, the court, in an opinion by noted executive power defender William H. Rehnquist, right, upheld that part of the Ethics in Government Act of 1978 that created an independent counsel who could only be removed by the Attorney General for cause. And you mentioned IEPA as a post-Watergate reform. The Ethics in Government Act was also a massive post-Watergate reform.
That was the marquee post-Watergate reform.
100%. And it reflected an idea that was not new at the time, but was that Congress is entitled to create at least a modicum of independence within the executive branch. The Supreme Court had blessed that as early as 1935 in a case called Humphrey's Executor. In Humphrey's Executor, the court unanimously, which if you know your Supreme Court from 1935 was not a given, right, unanimously upheld Congress's power to create a Federal Trade Commission with commissioners who could only be removed for neglect or malfeasance. And said that was not an unconstitutional infringement upon the president's powers. And Mona, a lot of the modern administrative state is based on those two ideas, that you could have quasi-independent agencies and that at least below the cabinet level, you could have quasi-independent officers depending upon the functions they were executing.
Right.
That's how we got through the 20th century. And what has happened as the Supreme Court has turned further to the right, especially with Justice Alito replacing Justice O'Connor in 2006, even John Roberts replacing Rehnquist in 2005, and especially Brett Kavanaugh replacing Anthony Kennedy. The court has come as close as ever to embracing the unitary executive theory. That is the theory on which President Trump can fire all these people in the face of statutes that say they can only be removed for cause. And you have these lower court decisions saying, well, the statute says they can only be removed for cause, and Humphrey's Executor and Morrison are still good law, right? And so you gotta, put these guys back into work. And then you have the Supreme Court. So Trump versus Wilcox, right, is the ruling that you were referring to. This is where the Supreme Court cleared the way on one of these emergency applications we were discussing earlier for President Trump to fire members of the National Labor Relations Board and the Merit Systems Protection Board. And Mona, part of why folks like me had been walking around saying, oh, I'm not so sure about whether Trump can do these things, is because of the exact exception the court articulates, right? It is really hard to embrace the unitary executive theory without embracing all of it, right? That the theory doesn't work if it has exceptions.
Right.
And so I had assumed that the court was not going to fully embrace the unitary executive theory until someone had come up with a coherent explanation for why the Federal Reserve was different.
Yeah.
Right. And just to put a bit of substance into that, right? The Federal Reserve's independence is actually really important to our economy.
Yes.
Right. I am not an economist, but the economists would tell you that central bank independence is critically important to the long-term stability of modern economies. Right. If you remove the independence of the Fed, even if Trump didn't fire any of them, just the mere fact that he could, right, would create massive instability on Wall Street. And that's bad for, everybody. So, the theory had been that the court was not going to take this step because no one had come up with that explanation yet. Well, not to worry, because the Supreme Court in a 2-page order, right, says, well, we're not so sure, Humphrey's executor, it's not consistent with the unitary executive. And then said, oh, and about the Fed, don't worry, obviously the Fed is different.
Yeah,
right?
And they didn't explain,
So
which is your
sentence.
big complaint.
Right. There's one sentence, and the sentence is, I don't have it in front of me. The sentence is something to the effect of, the Fed has a different history and can be traced all the way back to the first and second National Bank of the United States. Right.
Yeah, come on.
So first of all, you don't need to know that much constitutional history to know that the constitutionality of the first and second national banks was quite a big dispute.
Yes.
Second, right, there's about 80 years between the demise of the second bank and the creation of the Fed. So, the court is sort of pretending those 80 years don't exist.
Yeah,
but
exactly.
Third, and this is Justice Kagan's point, if the Fed is somehow worthy of independence, then that assumes that there are going to be some government functions that are worthy of independence. Right, that assumes there are going to be some government functions that are worthy of independence. And then the question is, well, then which functions? And so this is the problem. You cannot fully embrace the unitary executive theory if the unitary executive theory has exceptions that the Supreme Court invents on a daily basis.
Yeah.
And here we are.
All right. So what do you predict is going to happen on the birthright citizenship case? Eventually, they're going to get to the merits.
Probably. So there's a universe where that case actually never makes its way back to the Supreme Court.
Oh, really?
Probably not. But let me sort of flesh it. So we've already seen, Mona, on remand. The Ninth Circuit in the Washington State case has reaffirmed the universal injunction that the Supreme Court said you weren't supposed to do unless it was necessary to provide the party with, quote, complete relief. Well, the Ninth Circuit just held that at least for state plaintiffs, such an injunction was necessary to provide complete relief. And then in a wholly separate case, a district judge in New Hampshire has certified a nationwide class action and has enjoined the birthright citizenship executive order as applied to every member of the class, which is everybody, or at least everyone who would be affected by the order. So, it's possible, Mona, that the government doesn't appeal those decisions and the government just takes the loss.
Okay, well, that would be all right.
I'll just say, at least in the New Hampshire case, right, the judge in New Hampshire gave the government a week to appeal to the First Circuit, the Federal Appeals Court in Boston, and said, I will stay my order myself for 7 days so that you can go up to the First Circuit. And the government didn't. So, it seems possible to me that the smarter lawyers in the Justice Department are saying, let's fight on, class certification, and let's fight on when a universal injunction is necessary for complete relief in other cases. And let's just, we got as much as we can out of birthright citizenship, and let's give it up there. That's at least the possibility to me. It's also possible that they take the Ninth Circuit case and try to get the Supreme Court to say that the states don't have standing, which would be yet another procedural way to not decide the birthright citizenship question. So, my sort of, I guess, Mona, the short answer, which I should have started with, is I don't think that executive order ever goes into effect. Whether that's because the Supreme Court says it's unlawful, or whether it's because it's never given the opportunity to review, for example, the New Hampshire class action, I'm less confident about.
If you were advising law firms, universities, media companies, lawyers of various levels in our system about how best to preserve the rule of law in this country, what would you advise all of those different players?
I hope you'll forgive this answer because I'm going to say it anyway. The first thing I would advise them is that they should rewatch, or if they haven't, they should watch The Empire Strikes Back. And in particular, they should spend some time with the scene at the end of the movie when Lando Calrissian rues the fact that he agreed to enter into a deal with Darth Vader. Right? And comes to the realization that everyone, of course, had before he did, that you don't make a deal with Darth Vader. Right? And so it seems to me that like the sort of what some folks online call the Lando test is what is needed, which is, can you really tell yourself a coherent story that making a deal today will protect you tomorrow? And if you can't, then I think that changes, or at least it ought to change, the calculus for a lot of these institutions.
One last thing. What is the feeling that you're getting from students? Do they recognize just how crazy the world is to somebody like you who grew up with the expectation that there were certain norms and rules that would always be there and is now seeing the ground shifting? Or do they just think this is all sort of part of the way the world is?
So, I mean, as you know, I teach at Georgetown Law School, which is probably at the extreme end of the spectrum if we were ranking law schools on how plugged into the real world students are. And at the extreme, like plugged in end of the spectrum, maybe too much so. It might be better if my students were a little less plugged in to that. So I think, my students compared to, say, the median law student are probably both more cognizant of the abnormality of the times we live in, but I think also more predisposed to believe that those norms were always soft. And that, and that political power is going to win more often than principle. To me, the tricky part, Mona, I'm going to have 122 first-year law students in civil procedure this fall. And I love teaching first semester civil procedure because the students come in predisposed to hate the class. They have no idea what it's about. And I can sort of, I have a chance to actually really make an impression there. Whereas in like a constitutional law class, they all come in with fairly strongly preformed views, right?
Yes.
But one of the things that civil procedure I think is really important for now more than ever is explaining to students why process matters. And the sort of the role of institutional process in the rule of law. And it seems to me that you can believe, and I'll just say I do believe, that that principle is under assault to a greater degree than we've seen in American history, but that it's still very vibrant. And that it's still doing an awful lot of work on a day-to-day basis, maybe not in the cases that get all the attention in the news, but in the cases that most of us will actually experience in our lives. And the fight for people like me, right? The turf we are contesting is to make sure it stays that way, is to not let everything become who has power and who doesn't. And that, I think, is the challenge for not just law students, for students in general these days, and especially for the people like us who have the responsibility of trying to educate them.
That's wonderful. You referred to a movie, so I'm going to also refer to a movie, although I don't remember exactly which one it was. It's not that important. It was about, like 16th or 17th century England, and there's a character who is at home in his study, and armed soldiers of the king come through the door, and they say, they're taking him away, and he has his servants around him, and he says, "Where is your warrant?" And they say, "Well," and they look at each other. What's this? "Oh yeah, you are supposed to have a warrant." "Oh, okay." And then they have to leave. Okay. So it was a very affecting scene when I saw it as a teenager, and it drove home to me the importance of process that has been bequeathed to us through Anglo-Saxon law and down to our own time, through centuries of accreting procedures and protections that are the foundation of our liberty. And people tend to slight process. They want to get to the meaty stuff. They want to get to the issues, but process is key to everything. And I know it's a little bit of a nerdy point, but I believe that firmly, and I think you do too.
I do. And I'll just say, one of the opinions we spend a lot of time on in law school is Justice Jackson's concurring opinion in the Youngstown case. Jackson closed that opinion with a quote from a Rudyard Kipling poem called "The Old Issue." And the quote is, "Ancient right unnoticed as the breath we draw, leave to live by no man's leave underneath the law." He did that for a reason.
Yes. Brilliant. Thank you so much, Steve Vladeck, for joining me.
Thanks,
and
Mona.
for everything you do.
Great. I appreciate it.